The big question: opinion doves fly to ledge on the West Front of Supreme Court on October 2. As the new year begins, Post Opinions columnists write about the biggest questions about 2024 and beyond. Donald Trump has made a career of manipulating the legal system to his advantage, evading responsibility for allegations of misconduct, and using lawsuits as a weapon against enemies. If courts get their hands on the situation, this could be year things change. With 4 criminal investigations and a series of efforts to bar Trump from running. Challenge for judicial system, particularly 9 justices at top of system, is whether it can hold Trump accountable in a manner consistent with his election decisions, fair to the Constitution and fair to Trump, and do both in a way that lets voters know whether the presumptive GOP nominee has committed multiple felonies before voting begins. The outcome of the election may be at stake. The progress of 2 federal investigations offers contrasting case studies in what to do and what not to do. The election interference case before U.S. District Judge Tanya S. Chutkan in Washington is mostly a lesson in proper case management. After Trump was indicted last August, Chutkan set a trial date for March 4. This program was extremely ambitious and will likely not be met as Trump continues his absurd and meaningless claim of absolute immunity from the presidency. But he gave Trump a full 7 months to prepare and would allow the trial to conclude before the general election campaign was in full swing. Chutkan quickly decided to deny Trump's claim, and he tried to contain the most dangerous part of Trump's outbursts against prosecutors, court staff and witnesses, which is where the real part comes in. Chutkan's gag order sought balance Trump's First Amendment right to attack the prosecution with the need protect witnesses and court staff from intimidation and potential violence. When inevitably appealed that decision, an appeals court panel found that the decision went too far in preventing Trump from personally going after special counsel Jack Smith and was too vague in preventing from targeting witnesses. But there is another basis for optimism. The panel that modified Chutkan's order consisted of 3 appointees of Democratic presidents. It's safe to assume they weren't Trump fans, but they treated Trump's First Amendment rights, especially as a presidential candidate, with the utmost seriousness. Trump took dispute to the full appeals court, of course, but system is working as it should. That's not the case in Florida, where Trump-appointed District Judge Aileen is moving slowly on what should be a fairly straightforward case. Cannon got off to an inauspicious start in classified documents case by taking extraordinary step of appointing a special agent to oversee government's review of documents seized by FBI. The appeals court slapped him, but Cannon doesn't appear to have been punished. She, on con.